afternoon, my name is Shautsova. I'm an immigration attorney from Brooklyn, New York. In today's video, I would like to share with you the most recent immigration news and immigration updates. We're going to talk about the recent trends in USCIS, immigration courts, and what Biden administration is doing to change our immigration system. Thank you very much for joining me. If you have not subscribed to my channel, please do so and hit that notification bell button so you will stay updated with regard to the most recent immigration news. So let's start. Well, first of all, I wanted to share with you great news that it seems that USCIS is slowly returning to the policy of waiving certain adjustment of status interviews and some in-person interviews for certain other applications. This is great news because you may be aware that in October of 2017, almost as soon as Trump got into the office, USCIS announced that every applicant for adjustment of status and for asylum benefits derivative asylum benefits will have to be interviewed in person, which of course caused great backlogs and basically resulted in inefficiency of the United States immigration system, what we are seeing today. The result of that decision, what we're seeing today. But the current administration is going away from that policy, and I'm pleased to share with you that a lot of employment-based adjustment of status applications, some family-based adjustment of status applications, and I do not believe we're talking about traditional marriage-based application. It's more where a parent or son or daughter is sponsoring a family member. Those interviews are being waived in many cases, as also I-730 petitions related interviews are being waived. Usually, before the interview is going to be waived, an applicant would receive requests for more evidence to update their medical exam, and do not confuse it with a deficiency notice. That is a request for more evidence to update their medical exam or to provide passport-style photos, or perhaps to provide I-485 Supplement J confirmation that the petitioner is still going to have a bona fide job offer from the employer. So there will be that short request for more evidence, and shortly thereafter, a person usually would receive a green card. So this is great news, in my opinion. Another point that I wanted to discuss with you is USCIS changing its approach to naturalization. You may be aware that today, I believe, President Biden is going to hold naturalization event in the White House, welcoming immigrants to become new citizens. It's very important because it sets the general tone of how USCIS is going to treat naturalization applicants. Hopefully, we're going to see more positive changes. USCIS is already changing a lot of their policies regarding naturalization, making it easier for certain immigrants to receive U.S. citizenship. For example, they announced that, of course, there is a big announcement about the general policy that they're going back to the policy where they're going to respect and defer to their prior decisions. That's number one. Also, that now, if somebody was involuntarily and perhaps without even their knowledge registered to vote in the United States in the federal elections, it's not going to be applied against them during the naturalization proceedings. It's very important because previously, let's say a person would file for driver's license and automatically would be registered to vote. And in certain situations, it created a problem and permanent ineligibility from receiving U.S. citizenship, because it was regarded as claiming U.S. citizenship, guys. It's very important to know that this policy, automatic rather cancellation, is being abandoned, and now you may still be subject to this ban to become a citizen if you voluntarily and knowingly registered to vote, just so you know. And lastly, I wanted to share with you an important update regarding immigration courts. Immigration courts are going to reopen, guys, for non-detained hearings, not only in New York, by the way. I received many questions asking what are those courts, not just New York, Texas courts, Kansas, San Juan, El Paso, Harlingen. There is a full list of courts that are going to start processing again master and individual hearings. And a couple of things you need to remember. I have my previous video telling you how, in generally speaking, to prepare for the immigration hearing, but also I wanted to share with you a couple of the trends that we have now in immigration courts in the light of the prosecutorial discretion. It's possible now again to file for a prosecutorial discretion in forms of motion to join, to terminate one's proceedings if, for example, a person got married with a U.S. citizen and now can file for adjustment of status based on that marriage. It may come in a form that this discretion may come in a form of joint motion to terminate. Most likely it will be government's motion to dismiss the charges based on changed circumstances. Very, very important. Also, recently we received a decision confirming judge's discretion to rescind an order of removal issued against someone when he or she did not show up for their hearing. Judges have discretion to find exceptional circumstances considering all the evidence that will be presented in front of them. Very important because basically if you miss your hearing, you will be ordered deported automatically. And at times the judges would deny motions to reopen such orders of removal, citing lack of authority or lack of exceptional circumstances. So it's been confirmed that judges have broad discretion to decide if person's inability to attend fell into that exceptional circumstances ground that would allow them to reopen one's case. And the importance of this cannot be overstated, just because if you have an order of removal, you are, first of all, can be physically deported outside of the United States. Second, you may have very difficult time to impossible time fixing your immigration status and actually receiving some immigration benefits in the United States. Do not get into this situation. Try not to, and not to miss your hearings. Very, very important. Lastly, Ms. Chavez's motions to reopen. The deadlines are moving up and coming up. Deadlines to file motions to reopen in those cases where the initial proceedings against you were started with defective notices to appear, not orders to show cause, but notices to appear. When notice to appear did not have time and date where your hearing would take place, and later you received a notice of a hearing specifying time and date, and let's say you were deported as a result of those proceedings, you're still in the United States, you may file for the motion to reopen if now you can qualify, for example, for cancellation or removal. Very, very important. Ms. Chavez, you can Google using this hashtag. You will receive a lot of information, but of course consult with an immigration attorney to see if this is something that can help your situation. And usually you will be able to file for the cancellation of removal if you have been residing in the United States for 10 years continuously, you are a person of good moral character, you have U.S. citizen or lawful permanent resident spouse, parent, or a child who you can demonstrate will suffer extreme hardship, or rather exceptional and unusual hardship in case of your removal. And that's called sometimes 10-year cancellation or a green card, 10-year green card with a judge. This is what I am talking about. Now, again, you may have a second chance at it. if the proceedings against you that resulted in the removal were started with a defective notice to appear per United States Supreme Court decision. Thank you very much for watching, guys. Please like, share this video, subscribe to my channel, and I hope to see you soon.